Okay, you can start whenever.
Okay, good morning, Your Honors. May it please the court, Crystal Kochi on behalf of the state of Florida, the appellant in this case. If I may I reserve 5 minutes for rebuttal?
Sure.
Your Honors, the appellate in this case, Stevie Swinson, was charged with failure to acquire workers' compensation coverage for a time period of about 7 months in 2022. And so he ended up filing a pretrial C4 motion to dismiss. The trial court heard that motion, granted the motion, and we are here today on the state's challenge to the granting of that motion, claiming it was an error because the state, it believes, did establish a prima facie case that Mr. Swinson knowingly failed to secure workers' compensation insurance, or in lieu of that, an exemption. And in doing so, the trial court improperly reserved disputed factual questions that should have gone to a jury. So essentially, the trial court expanded its role from its limited function of here just testing legal sufficiency, and went beyond that to weigh the strength of the evidence and make certain credibility determinations based on the inferences. So I'll start with, and subject to the court's questions, I'd like to start with the second element of this crime. There are three elements. One, that the employer status of this particular employer is subject to Chapter 440 to acquire workers' compensation insurance coverage. Two, that the employer knowingly failed to get coverage, and that three, that for purposes of this third-degree felony, that the monetary value of the failure to get the coverage was $20,000, or I'm sorry, yes, $20,000. The value of such is $20,000 or under. And so the state takes the most, or it's causing the most consternation for the state, the second element. And I know that was not really much of a feature of Mr. Swinson's argument, but the state is arguing that the knowledge and failure element did present to this court an issue of fact that should have gone to the jury. A reasonable jury could have concluded, or could conclude, that Mr. Swinson knew of his obligation and failed to act. Now, some of that conversation includes an issue with intent, because whether Mr. Swinson intended to not seek workers' compensation coverage, or in lieu of that, an exemption, or as the trial court called it, called this a negligent oversight or a technical violation, or otherwise was inadvertent, that in and of itself shows that intent was at issue. This is the law is clear that when intent is a fact in dispute, this necessarily needs to go to a jury. So even if we just looked at this case alone with element number 2, that ends the C4 inquiry right there. And I'll touch briefly on monetary value. So Mr. Swinson's argument.
Before you get to that, Ms. Kochi, one question about, actually two questions. The first one, in the cases that were cited in the briefs, I didn't see anything quite like this case, and I understand what the statute says, but has there been any reported case where someone was charged criminally under circumstances like this?
Not that the state is aware.
My second question, restitution is typically available when there's a monetary loss. So exactly who is the victim that's going to get restitution if it were to be awarded in this case?
So and to answer that question, I'm going to tie in a conversation about the Carozzo case, because sort of additionally, in response to your first question, Your Honor, that is the closest case we have to anything similar to the circumstances presented here. So in the Carozzo case, it made sense that the conversation dealt with monetary value as and equating it to loss, because that, first of all, dealt with a different subsection of 440. That was a 4B1 misrepresentation case, whereby loss made sense because there was a certain benefit being obtained through those misrepresentations. But here, we're just talking about a failure to get workers' compensation coverage. And the state's argument is that value is not synonymous to loss, because even the language that is included in the Carozzo case says that the value can be a type of monetary loss or potential loss. So if we take the potential loss, if we're going to talk about loss, and apply it to this case, the potential loss was the non-payment of essentially a workers' compensation premium to the insurance carrier.
Non-payment of a premium that no one is claiming should have been paid. No one in the sense of a victim claiming that it should have been paid.
Correct. So, and here, so again, victim, injury, loss makes a lot of sense with the misrepresentation case, but here, just simply a failure to get coverage. Of course, there's not going to be anyone injured, and that was something that was included in the trial court's order, therefore imposing an additional requirement or element that the state has to prove. So to impose on the state to prove injury, loss, those are elements that the legislature did not include in this statute. So nothing in the plain language of our subsection 4A3 says anything about loss.
It says I'm sorry, maybe I'm misrecalling. I thought what was the language about value or loss? Remind me.
So 440-105 4A3, this is the subsection under which Mr. Swinson was charged. Failure to secure, so sub 3 says, fail to secure workers' compensation insurance coverage if required to, and then moving down to paragraph 4, subsection F, if the monetary value of any violation of this subsection, et cetera, it says nothing about loss. So that's what the state says.
You think the monetary value under this kind of circumstance can be something other than any real loss?
Correct, because the state's position is that when we're talking about value, it really is to classify the offense, because there are 3 different tranches here. So it's a 30-degree.
Let me ask this: is every workers' compensation carrier required to charge the exact same amount for coverage?
I'm sorry, could you repeat that one more time?
Is every workers' compensation carrier in the state of Florida required to charge the exact same amount for coverage, depending on the number of employees? There are obviously factors that come into play, but are they required to charge the exact same amount?
Not the exact same amount, and the state.
So how does the state determine the monetary value if it can vary based on whatever the insurance company deems as an appropriate premium to charge?
And to answer your question, Your Honor, I would point to the affidavit from a representative from the Department of Financial Services, who included in her affidavit essentially the equation that is used to determine what that premium cost would be. So but
that premium cost is speculative, isn't it? Because the premium cost could vary by insurer.
It could, yes.
Okay. The other question I had, and I think this is really my last one, when we look at the history of how the state has enforced these kinds of situations, am I correct in understanding that other than this case, as far as we know, it has always been handled on an administrative basis? Fines, there may be some suspension possibilities or dissolution requirements for the entity, but am I recalling correctly that that traditionally has been how these have been handled?
As far as I'm aware, that is true. That certainly was true to a certain extent in the Carozzo case, because there we were talking about that, non-criminal sanctions can't constitute the value for the purposes of monetary value. Now, the reasons for why this was not sought after, this was not an administrative sanction or the like, or something that was handled civilly. I'm not in a position to speak to that. It's not clear from the record. I'm not aware of what the background was leading up to this disclosure, which resulted in the criminal charges.
Ms. Kochi, for purposes of the C4 motion, excuse me, the state agreed that Mr. Swinson was eligible for an exemption, correct?
Correct.
And if that's the case, can it really be said, for purposes of the criminal statute, that insurance coverage was required to obtain coverage under the chapter?
If he, and I apologize, I don't have the requirements in front of me for what constitutes an eligible employer, but.
Well, I'm reading the criminal statute, that it's a crime if the employer, and I know there's a dispute about whether he was properly the employer, but assume that he was.
Mhm.
And we also know, as a matter of fact, that he could have been exempt just by filing a form, correct?
Correct.
So can it be said that he failed to secure workers' compensation coverage that was when he was required to do so by the chapter, if the chapter said that he could be exempt?
So, yes, the answer to that question, Your Honor, is yes.
How come he was required for the purposes of the crime? How can it be said that the chapter required him to get coverage if the chapter also said he could be exempt?
Because the exemption is not the requirement. So not everyone is required to seek an exemption. So it's either get the coverage or in lieu of that, get an exemption. I'm sorry?
Or get an exemption,
Or
but
get an
the
exemption.
exemption was available to him, and I don't think there's any dispute that he qualified for it.
Correct. He's done it twice before.
Correct.
So what the state, so if we're looking at these 7 months where Mr. Swinson neither had coverage or sought an exemption, was that, and this all goes back to the knowledge, failure to act, and intent question, which is, was that failure to act intentional, where a reasonable jury could potentially conclude Mr. Swinson realized he wasn't covered by
But
any.
the statute doesn't seem to penalize failure to ask for an exemption when one was eligible for one.
Right, and that's.
It penalizes failure to get coverage if required to do so by the chapter. And we know that the chapter also provides for an exemption just by filing a form.
Correct, but, and I understand Your Honor's question, because that very similarly, Mr. Swinson makes the argument that no, what the statute is saying is it's not criminal to not seek an exemption, but the exemption is not the requirement, because again, either you get the coverage or you get an exemption, or if you're not going to get an exemption, you don't start working until you get the coverage. So those are kind of the three options. And frankly, an exemption, if someone similar, Mr. Swinson or someone similarly situated to him has one, that is a defense to not having workers' compensation coverage. If you are, sued and somebody says you're not covered, oh no, wait a minute, I have this exemption, that's a defense. The exemption is not a requirement. It's available, but it's not required to get. So going back to, again, tying all of this back to the knowledge and intent thing, a reasonable jury could find that Mr. Swinson either intentionally failed to get this exemption, where, for example, he starts working, realizes he's not covered, decides, you know what, I'm not going to worry about it, nothing bad is going to happen, and just not seek it, or a jury could come to the conclusion that he was, it was a negligent oversight, apparently for 7 months. So just the fact that that could be viewed two different ways, that is an issue and dispute, and it should have gone to a jury. And so if this court, the practical consequences would be, if this court were to affirm this, that essentially would be taking intent and making it a legal conclusion, and taking that out of the hands of the jury for proper consideration. And if there are no further questions, I'll yield the remainder of my time for rebuttal.
Right, you have your 5 minutes. Ms. Hatfield?
May it please the court, counsel, my name is Victoria Hatfield. I represent Mr. Swinson, the appellee in this case. Our overall position is that the legislator did not intend to imprison a sole owner for failing to insure himself when the statute authorizes his exemption in the first place. And I think understanding this exemption is very important to my argument. The legislator has built into Chapter 440 a deliberate choice. A corporate officer may exempt themselves from workers' compensation coverage altogether. And by creating that exemption, the legislator is specifically telling us that safeguarding premium payments to insurance company in certain circumstances is not the statutory purpose. That is not the concern to the legislator in certain circumstances. The legislator is expressly allowing certain circumstances where insurance carriers are not automatically entitled to premium payments, and the legislator is allowing certain circumstances where no workers' compensation coverage is required. And the reason why the legislator is allowing this is because exempt eligible employees are not the type of employees that this whole chapter is seeking to protect. The legislator, through this chapter, is seeking to protect employees that are supposed to be covered and are uncovered by a separate employer, or who think that they're covered and are uncovered. The statute's also seeking protecting insurance companies from fraud, so preventing people from getting paid out when they're not entitled to be paid out. It's not seeking to protect an unprotected officer who has the authority to choose to be unprotected. So I think we have to start with the premise that the legislator has decided by way of this exemption that a qualifying officer need not insure themselves. So it would be illogical to conclude that that same legislator is simultaneously intending to criminalize that sole owner for not paying an insurance premium they weren't required to get in the first place. And the key word is criminalize. Should there be consequences? Absolutely. And I think that's been touched upon already. Should there be administrative fines? Yes. Should there be a suspension or a stop work order? That all needs to be looked at, but not the potential for 5 years in Florida State Prison, which is what this offense is punishable by. With regard to monetary value itself, I think there's 2 ways that this court can look at monetary value. And if we look at the wording of the statute, subsection 4F of the statute specifically references the monetary value of the violation. So I think you then focus on, well, what's the violation here? And if you look at the wording of the statute, it specifically says it shall be unlawful for an employer to knowingly fail to secure workers' compensation coverage if required to do so by this chapter. So again, this has been touched on. The monetary value has to be tied to the violation. So in the very specific limited circumstance of an exempt eligible employee who is not required to get the insurance, the violation actually becomes the failure to get the exemption, not the failure to get the insurance. And the failure to get the exemption is non-criminal, and it also carries no monetary value to it. The second way that I think this court can look at monetary value is honing in on the Caruso case. We know that monetary value is an element to defense, and we also know that it's not defined in this particular statute. And Caruso tells us that it must be strictly construed in favor of the defendant. And that's why I've gone over the legislator intent and honed in on this exemption, because we have to consider that when we construe that term. And ultimately, what this court did in Caruso was they found that an administrative fine is not the proper measurement of monetary value in that specific circumstances. And I think this court has the option to do the same thing. I think this court can say, okay, in the limited situation of an exempt eligible employee, the hypothetical unidentified insurance company who never had a legal right to a premium, that is not a proper measurement of monetary value. Although you can come up with a speculative figure, that is not a proper measurement of monetary value. Caruso also talks about potential loss. I know we've talked about loss. The state is arguing that they're not necessarily arguing loss, but I think by saying the lack of a premium payment is the monetary value, that's loss. That's a potential loss to an insurance company. And in response to that, I would say you can't lose something you were never entitled to have to begin with. With regard to going back to just the basic wording of the statute, I would draw the court's attention to the fact that the beginning of 440.105 subsection 4 specifically says whoever violates any provision of this subsection commits insurance fraud. So it's specifically talking about fraud there. So when it says it shall be unlawful for an employer to knowingly fail to secure workers' compensation insurance coverage, if required to do so by that chapter, that conditional language, if required to do so by this chapter, is protecting employers who legitimately aren't required to get coverage from an allegation of fraud. That is the purpose of that conditional language. Touching upon employer versus employee. If Mr. Swinson is not considered an employee, there is no insurance requirement. But at the same time, the state also has to consider him an employer because then the statute doesn't apply. So for the state's theory to work for a one-man show like Mr. Swinson, what we have here, they have to treat him as both the employer and the employee. And I would submit that that goes against the whole structural logic of this statute. Again, we're here to protect employees from separate employers, not covering them. So I think the argument is the employer has to be different than the employee for this particular offense to apply. And Mr. Swinson is not the employer intended by the legislator. With regard to the state's argument on the trial court addressing knowledge, I do want to point out that the trial court's order specifically found that there was no monetary value to the violation as a matter of law. That was a finding by the trial court. I think specifically the trial court, and I'm paraphrasing, found that the loss was speculative, and it was kind of zeroed out when there was no premiums required. So the trial court made that specific finding, and monetary value is an element to the offense. So if there's no monetary value as a matter of law, as the trial court found, there's no need to go into knowledge and intent. Knowledge and intent of Mr. Swinson was not argued by the defense at all. It is nowhere in the motion. I acknowledge that the trial court talked about intent and whether or not Mr. Swinson intended to commit a crime, but that wasn't the basis for the denial. The basis for the denial was the fact that there was no monetary value, and this court's standard of review is de novo and can similarly find that there was no monetary value to the violation. If there's no questions, I would say in conclusion, the monetary value element cannot be satisfied as a matter of law. The state has conceded that has an exemption been filed, there would be no premium obligation in this case. And I think that concession aligns with the statutory design in this case. The same statute that authorizing employers to opt out cannot then be read at the same time to prioritize those premium payment collections from those same officers. And for that basis, I would ask that this court affirm the trial court's decision dismissing this case.
Thank you, Ms. Hatfield. Excuse me. Ms. Kochi for rebuttal.
Yes, thank you, Your Honor. Just briefly. I understand my colleagues' explanation about legislative intent and what have you. But we're not here on Mr. Swinson's challenge to the statute that it's vague and it doesn't put him on proper notice that, or what crime he's committed. He's not making a facial challenge or an as-applied challenge. So legislative intent in the state's mind, or it's the state's position that that doesn't need to factor into the conversation because of the plain language of the statute. What it sounds like to me, or what I was hearing, is that Mr. Swinson doesn't want this particular law to apply to someone like him, who is a sole proprietor, who falls under the category of employer who needs to seek coverage. That is not something that is in this court's wheelhouse to remedy. That is a legislative problem. So acknowledging how Mr. Swinson believes that these provisions might be absurd in application to him, we have to evaluate his case with what's on the words on the page here, and have the legislature, if it sees that we need to tweak this so that we don't get this result again, let that happen in that branch of government. And again, even if this court disagrees with the state about the employer-employee status or the monetary value conversation, the fact of the matter is knowledge intent was addressed. The trial court came out and said that no, there was no criminal intent. This was simply an oversight. This was simply negligent at best. And that alone was an issue and dispute that should have gone to the jury. So even just looking at that one element, that requires reversal here and should have ended the C4 inquiry at the pretrial stage.
Okay. Thank you both very much. I'm sorry. Did you have more, Ms. Kochi? You paused. I thought you were done.
Yeah, I'm sorry. I would ask, the state would ask this court to reverse and remand for further proceedings.
Great. Thank you both very much. In order to leave our virtual courtroom, you need to click the leave button, which I think is in the lower right-hand corner of your Zoom.